Hello? Court call operator is John McGuire.
Sorry, Your Honor. Yeah, I'm here. Yes, Your Honor. This is Gino Magna. How are you? On behalf of the Illinois.
Okay, Mr. Megna, and yes, he sounds like he's underwater, so it's definitely our system. We may have to shift you all over to Zoom. All right, and then on the plaintiff's side, ladies first.
This is Sandy Solomon, Allison Thompson with me.
Okay, and yes, and you sound like you're underwater.
Your Honor,
too.
I also have my client on the line as well.
Okay, that was Mr. Megna?
Yes. Your Honor.
Okay, let's see if we can switch to Zoom. Do you all mind doing Zoom?
We're not in a place that we can do that, but we could, if given a couple of minutes, we could do that. But we're not really situated to do that.
Oh, okay, then wait a minute. Wait just a minute. Let's see what we can do. I've got to get Lori or somebody here to come down and troubleshoot. If I hate to cause counsel to incur extra money by rescheduling another court call hearing. We actually have time up until really about 11 o'clock because the two 10:30s are going to go very fast. We're just going to be continuing those. And the reason we didn't do it out of the box is we have two pro se defendants, and we needed to tell them about it in open court. So the 10:30s aren't going to take that long. So just sit tight.
We hear you just fine, and we could hear the other parties on the other, and everybody in the first hearing as well, Your Honor.
Yeah, I understand that, but I can't hear you very well. And you all are going to make real arguments. I'll tell you what, let me talk. I'll talk for a while. All right, what I see here on the motion to strike the affirmative defenses, Mr. Magna, I think most of that is well taken. I think with regard to the one on damages and the one on ordinary course, those are really just denials. You know, to be accused of embezzlement, you deny it. Why do you deny it? Because it wasn't embezzlement. It means that you didn't come into possession of funds legally and then convert them to your own use without permission. That's a denial. The section 548C, I don't know when you're looking at a 523, and then there's a 727, but if you're looking at 523s, you're looking at defenses under the 523s. And so you wouldn't mismatch the defenses, okay? And maybe you all have already talked about this and I'm wasting my breath. On the other hand,
No, Your Honor, that one,
Mr. Megna?
yeah, no, I agree with you. That one I was going to remove any look at that one. That should have mentioned being that the 548C.
Okay. So I went through some of those. I also know that there's a motion for a ruling on third-party discovery in a case that's not my case, my adversary proceeding, and I can't rule on those. I don't have any jurisdiction. The alternative is for me, and I'll let you all vet this, I can abstain for a while, in other words, abate this adversary proceeding, let you go over to state court, finish out your business over there, bring me back the result, which will drive my decision under principles of collateral estoppel. That's one choice. Another choice, and frankly, it might be my preferred choice depending on what you tell me about how long the state court has had it. Another choice might be that you issue identical discovery in this adversary proceeding over which I would have jurisdiction to call balls and strikes on objections to motions to compel or call balls and strikes on a motion for a protective order. I can tell you that based on the allegations, I would be very reluctant to block that kind of discovery. I think it is relevant based on the claim that is pleaded in the complaint. And in terms of privacy issues, there's a balancing test under the state constitution for that. And, frankly, I'm not sure that credit cards, maybe there is some sensitive information if the defendant was purchasing things that might be embarrassing to her, and so forth. But we can fashion a confidentiality order as has been suggested. So that's kind of the way I was going to go on this motion for a ruling on objections to third-party discovery. Let me track back to the motion to strike affirmative defenses. There are a couple theories of estoppel, and it looks like the plaintiff is honing in mostly on collateral estoppel, but there's regular estoppel too, but there are elements to those under the state law. Let me see if I've got my WITES, W-I-T-E-S, Florida Causes of Action and Defenses book up here. Oh, I got the little one. Hold on. This isn't as good as as robust as the big one, but, it's the Supreme Court case on equitable estoppel it looks like this is an old book, 2002 Westlaw 31662590 at asterisk 3. There's a second DCA case cited at 816 Southern 2nd 832. I should give you the names. In the Supreme Court case, it's the Florida Department of Health and Rehabilitative Services, so FDHRS. The second DCA is Watson Clinic. There's an 11th Circuit case, TEFL, T-E-F as in Frank, E-L, 180 F3rd 1286. And there's also, I see, a middle district in this book. At any rate, and then there are defenses to a claim for equitable estoppel as well that you can pick up. Promissory estoppel, it's got different elements, and so, Mr. Megna, you're going to have to plead which theory of estoppel you're going under there. Is it collateral? Is it promissory? Is it equitable? And the way that we plead our affirmative defenses is as stated in the motion to strike. You plead it as if it's a pleading. You can't just use a name or a title of a certain kind of defense. You've got to lay out the elements rather precisely. Now, I don't mind a Rule 12b-6 defense pleaded as a defense. Let me get this. I saw the case law that, Mr. Solomon, that you cited, but it is true that 12 says that you can lodge these as a defense instead, and you don't need to do it in the form of a motion. But if you're going to do it as a defense, you're going to have to lay out which elements, Mr. Megna, you believe are missing. So you can't just say fails to state a claim. You have to say, what did they leave out? That's how you plead an affirmative defense on a motion, on a 12b, failure to state a claim. One last point. Judge Moody always says this: unless you know that there is no way they could plead a certain kind of claim, you should sit on your hands and not raise a motion to dismiss, because it gives them a chance to fix their pleadings. That's the message he gives young lawyers. And that's a message I give you, because you're a young lawyer. And so I've given you a lot of stuff, and I've talked a lot. We still don't have a technician here.
He's on his way.
On her way? On his way? Hey, Bill. Bill McGinnis is here. So what if I were to send you back, Mr. Megna, and give you an opportunity to replead the affirmative defenses? I would grant the motion to strike, except for I would grant it, but I would permit you to include the failure to state a claim if you choose to re-include it with precision. And how much time would you need to replead the affirmative defenses, Mr. Megna?
Judge, if you give me a got 2 trials, it'd give me like 7 days.
You can take 14. Okay? Same with waivers.
I'll take that.
Same with waiver too. I'm getting that the theme here is these people, the principle behind the
Your
company.
Honor, a big one is latches as well, Your Honor.
Yeah, and latches, you know, that usually is the statute of limit. It usually is guided by what the statute of limitations is. They usually run hand in glove, but you can replead latches, but then we'll probably have a dispositive motion on that one. And there's case law out there that talks about when latches is good and when it's not good. And it's maybe that there's now insufficient documentary evidence because of the lapse of time and that you shouldn't be bound by just the statute of limitations. But do some research on latches and when it's appropriate. So I'm going to allow you to replead. You can have 14 days. And we'll do a jiffy order for you, Mr. Solomon. Mr. Solomon, jiffy order is something we just do a checkbox. We grant your motion to strike based on the colloquy on the record, and then there's a line that says, defendant shall have 14 days to replead the affirmative defenses. Is that okay with you?
Yes, ma'am. We have discussed this at the Conference of Counsel, and I had thought that Mr. Mega was going to replead because if he repleads with the specificity that we believe is required for each and every one of the defenses, then we can go from there. We'll just reply, close the pleadings, knowing what he's talking about, but merely raising an affirmative defense by appellation isn't sufficient, and Mr. Mega and I had discussed that. We had thought he was going to do that before today.
Okay, well, he didn't, but you've got the motion. I've ruled on it, and he'll do that. Now, with regard to the objections on the third-party discovery, how long has the state court had the case?
The case has been outstanding since August or September, and with respect to these discovery requests, we served third-party subpoenas and discovery requests directly to Ms. Antonio. They haven't produced anything. They filed a series of objections, and we've been at this with prior counsel before Mr. Megna got involved in the state court case. And we floated the idea of the confidentiality agreement and have now sent that 4 or 5 different times without response. I think it's a very simple question because we don't have any objection to limiting the exposure that Ms. Antonio may feel by having a confidentiality agreement, and now that it's been out there for 2.5 months, 3 months, I think that we could probably resolve this if they would just respond to the confidentiality. The state law is very clear, as you had indicated, was your understanding of the law anyway, that if the discovery is relevant to claims that are pled, and our complaint is pled with great specificity, that we are entitled to that discovery. Much of what they raised initially in the state court was that these were not documents that belonged to Ms. Antonio, but that they belonged to DGP, and that was the reason why we shouldn't be able to seek the discovery, but that's a non sequitur. And then we said there are a series of documents that were created, or accounts that were created in the name of DGP by Ms. Antonio that we do not know of, and that's part of the problem where we go to these third-party providers, whether they be credit cards, banks, or if you will, software apps that are used in the business. And this has been going on for 4 months without an ability to actually have a hearing in state court. And what we were trying to do by filing the motion with you was to avoid all of the expense of reserving all of the subpoenas and then waiting for objections again, and going through the process both time-wise and expense-wise, because they're the same objections that they raised before. In fact, what I would propose is that if they have any objections to the state court discovery that was already served on the third parties, that they merely refile those objections now before you and allow that decision to be made by you in this court, so that we don't have to go reserve, because we reserved and then we had telephone conversations with Citibank and Chase and Hewitt, and they're all over the country. So we've had to get subpoenas issued by the state courts in other states. That was an expense, and in some states, as you probably are aware, we have to actually open a new case, which costs somewhere between $250 and $500 just to open those state court cases to have a subpoena issued on those parties who don't have a direct presence in Florida and have to be served at the state, for example, on the West Coast. So this was merely an attempt to get a shorthand resolution, and we would like to avoid having to redo all of the discovery, and then deferring to the state court is just going to engender another delay. I don't even know whether the judge that was originally assigned to the case is going to remain in the same division, because as you know, they'll all switch in January, and with the new judges taking their seats on January 19th or 20th, that's going to just engender another delay.
Okay, I've heard enough. Hold on, I've heard enough. It hasn't been in the state court that long, so abatement is not an appropriate thing here. Now, the stay is in effect with respect to litigation in the state court. Unless Mr. Megna will agree and consent to treating that discovery as if it was made in this adversary proceeding and is subject to my jurisdiction, I can't really touch it. It's so much easier to issue discovery in bankruptcy court because you may simply mail subpoenas to these third parties with documents, and you need not, I don't think you need to go to any other bankruptcy court to have subpoenas issued. So it's very customary where we have people subpoenaing, Fifth Third Bank, Bank of America, wherever, and they get the documents in. I would urge you all to talk some more and look at Bankruptcy Rule 1001 and live by the spirit of it. And Mr. Megna, you are familiar with the case, I think, I probably have mentioned it to you, of Salyers versus Prue, SahlYers versus Prue, Prugh. The decision by Judge Edmondson. Judge Edmondson was Chief Judge of the 11th Circuit then, and he talks about the need for counsel to remember that you are your maybe primary duty is the duty to the court and the system in ensuring the just, speedy, and inexpensive determination of every claim. And he says that the lawyers are officers of the court in that regard. I think that what Mr. Solomon has suggested could be done by consent in the spirit of Bankruptcy Rule 1001. But I'm going to let you all talk about that, and I'll continue this hearing until after we have the affirmative defenses already in hand. And so if it's going to be a 14-day turnaround on that, something that's about a month away, and see if you can come up with a consensual resolution on this discovery. Mr. Megna, it's going to come in. It's going to come in. Frankly, the way I see this is there's a bunch of expenses. There may or may not be some irregularities in the creation of some documents. The defense apparently is that these people had a relationship with each other and that there was a free hand given to the defendant to do certain things. If she didn't report these things as income, that's going to be an issue. Unless, she can make a credible case that the company gifted her company treasury money. I'll tell you that I have an issue with I think there might be an issue with the fiduciary allegation, Mr. Solomon. That could come up on a dispositive motion. I also looked at the 727. That one I'm not convinced yet that that's the proper stuff of 727, but I haven't done any research. You'll have to find some cases, but that may be a dispositive issue. or right before a dispositive motion at some time. I do think you all should mediate.